First Appellate District of Ohio with the Honorable Maryland Science presiding is now in session. Please be seated.
Good morning. Good morning. And welcome to the First District Court of Appeals. Today is Monday, April 25th. I hope everyone was able to enjoy this amazing weekend that we had. Hopefully we'll get more of that weather this week. We have 4 cases on the docket. All are going to be arguing this morning. I'll be calling out the docket if attorneys can please identify themselves and their readiness to proceed. So the first case that we have is, and if I mispronounce someone's name, feel free to correct me, okay? The first case that we have is case number C210457, Krasik versus New State.
Yes, Your Honor. Tom Satan's on behalf of the appellant, Howard New State. Ready to proceed.
Michelle Lestagnero on behalf of Appellants, ready to proceed.
Okay. And the next case we have is cases numbers C210219 and 430, Minkhouse versus Minkhouse, Charles A. Minkhouse versus Nicole F. Minkhouse.
Michelle Lestagnero for Appellants, ready to proceed.
Phyllis Boston for the appellate. Mr. Minkhouse, ready to proceed.
Thank you. The third case is case number C210477, B&T Business versus Kentucky Deal Holdings.
Good morning, Your Honor. Nick Zuccarelli for the appellants, ready to proceed.
Good morning.
Good morning, Your Honor. Chris Jones for the appellate, ready to proceed as well.
Good morning. And our fourth and last case is case number C210363, State of Ohio versus Schilling.
Your Honor, Paul Croushore for Mr. Schilling, ready to proceed.
Good morning.
Morning, Your Honor. Ernest Lee on behalf of the state, ready to proceed.
All right, thank you. Because we have 4 cases, if counsel wants to step outside, feel free to do so. There is a conference room off to the side and there's speakers in there. But if you want to remain in the room, you're also welcome to do that as well. So we're going to start with case number C210457. Again, maybe I'm mispronouncing this, Krasik versus New State.
Good morning once again.
Would you like to reserve time?
Let me reserve 2 minutes, please.
2 minutes, all right. You can start whenever you're ready.
Okay. If it pleases the court, if I can give a brief summary of the facts. I believe that the facts in this particular case are most important because it underscores what we argue is the trial court's abuse of its discretion. In this particular case, the child was born on June of 2016. At that time, the parents were living together a couple streets away. The parties immediately separated when mother, Dr. Krasik, directed my client, basically kicked him out of the condominium. She filed a petition for support approximately 2 years later. Shortly after the birth of the child, Dr. Krasik hired a nanny personal assistant. And in approximate round numbers, that nanny was paid on an average $40,000 a year. Dr. Krasik is a board-certified pathologist. Her earnings are as follows. $225,000 in 2016, $259,000.
Counsel, I think we're familiar with the earnings, and you covered all that in your brief. The ultimate obligation here for your client is a little over $500 per month. Is that correct?
Current.
Okay.
Yes.
Okay.
The issue is, looking back, there were perhaps 8 or more child support worksheets. There are different periods of time. We had a change in the child support laws a little over 3 years ago. And it's greatly impacted by the number one driving force, I believe, is the child care expense. Number 2 was the extrapolation of the child support worksheet beyond the cap. And thirdly, it was the imputation of income to my client. And with the court's permission, I'd like to discuss those in reverse order of my assignment of errors.
Sure.
First, on the child care expense. 3 years ago, March of 2019, we had a significant change in child support laws. At that time, child care expense was capped, depending upon the age of the child, in round numbers around $8,000 a year. Prior to that, the issue is whether or not child care expense was reasonable or not. We would argue that no, $40,000 a year is unreasonable in child care expense. Certainly, having been over at 800 Broadway the last 30 years since they transferred.
And what factors would you ask us to consider you're saying it's unreasonable? What factors would you ask us to consider in that?
Well, I believe that the Ohio legislature has told us, directly or indirectly, what a reasonable amount is. I believe the $8,000 cap is a reasonable amount of child care, given the circumstances of this particular case. Now, here...
Well, there were other things that the trial court took into consideration. Isn't that correct? With regard to the child care expenses, there were other things that the trial court took into consideration.
There were other factors the trial court indeed took into consideration on the overall determination of the amount of the child support. But as it relates to the child care expense, there was very little evidence other than the fact that Dr. Krasik testified she's a doctor and she needs to have a nanny available in case she's on call. And this is also a nanny that she used as a personal assistant to run personal errands.
But weren't those for the family? I mean, from looking at what I read, it sounded like it was for groceries and things that benefit the child.
And, well, yes, we're talking about an incident, but yes, it was for groceries, but for the most part, it was for Dr. Krasik and her personal expenses and her personal needs. So, again, I believe that $40,000 a year or $39,000, whatever the court used, is way too high of a child support or a child care number. Now, as I said earlier, I agree with the cap that's put on it, and if the court would recompute child support, it would make it a more reasonable number. The other issue is the extrapolation.
Recompute child care.
Child care, I'm sorry.
Okay, that's okay.
The other issue raised is the extrapolation of the child support worksheet. I can tell you, I personally have never been part of a case, and I've never heard a case where there's been an extrapolation when you have the obligor as the lower income earner. In this particular case, you're looking at a swing of actual income of 10 to 1. Presently, Dr. Krasik is a $400,000 a year wage earner, and the testimony from my client was he hoped in 2020 that he would earn $40,000 a year. Now, importantly, this case was heard or tried in July of 2020, and as we all know, that was probably the height of COVID. And at that point in time, we were looking at unemployment of 25 million people, 15% unemployment rate, and is really the worst economy since the Great Depression. That's important for purposes of the court's determination of the imputation of income to my client, which we believe that there is no evidence of what his potential income is. Now, there's two components for child support, as the court's well aware, of determining what my client's income is. One is his actual income, and then if the court determines that he or she is voluntarily unemployed or underemployed, what that party's potential income is. And there was no evidence presented whatsoever as to what my client's potential income was.
What about the track record of his income prior to then, including when he started the independent consulting and made about $80,000 in the first year?
I understand that, and I agree with you. It's a good point. I would say, at best, my client's income history is spotty at best. It seems that he could not really hold a job for more than 6 months. He kept transitioning. In 2018, after working at 3 or 4 different places, albeit for a couple months at a time or 6 months at a time, sure, if you aggregate all those numbers together, yes, he was able to earn a modest income, we'll call it $70,000 a year. But in 2018, he elected to become self-employed. He had been an independent contractor at that point, and he hung out his shingle, and he certainly wasn't doing it for purposes of paying less child support. He thought he had the ability on a go-forward basis with his then fiance and now his wife to build their marketing business. So, if a person is not able to take a step forward and try to improve their lot, no one's going to change jobs. Because otherwise, it
But I
can't.
think there seemed to be some concern by the trial court insofar as he would incur substantial credit card debt on a monthly basis and yet pay it off. And the question is, how is he able to pay it off if he is only making $40,000 a year? Because the debt was, I think, like $7,000 to $8,000 a month.
Well, what the testimony was, which didn't really come out in either party's briefs, was that Howard and his fiance, or now wife, they just used one credit card, or they used his credit cards. So whatever their expenses were, personal living expenses, business expenses, and the like, they just used his card for purposes of accumulating points. That was a decision was made. And she was earning perhaps 75% of whatever their business income was. So yes, it does look like he was able to charge the certain amount of number, and then it would be paid off. But it was really paid off from his wife's or fiance's income.
But the income was from the business that they started?
Wife actually started the business. He joined up. He had a small part of it. He was responsible for doing marketing, and she was doing communications, some other part of the work. But the testimony was that in terms of allocation of income between the two of them for their personal services to the business, I believe his was either 20 or 25%.
So I want to make sure I understand your argument with regard to imputing income. Are you saying that your client did not have the ability to sustainably earn more than what was imputed?
I'm saying yes, that's correct. He was actually, it should be a lesser number, not a greater number, correct?
And so what would you point to in the record to support that had been established?
What part was established, please?
That he is not able to sustainably earn more than what was imputed?
Well, we don't know what his potential income was. There was no evidence put forward. We know what his actual income was. His testimony was in 2019, he earned $20,000. In 2040, he believed, subject to COVID for 2020, he thought he could earn $40,000 in 2020. The court imputed him to the court wanted, for child support purposes, they put him down at $80,000, so they imputed $40,000 to him. There was no evidence.
But you're saying that he thought, what was the evidence that he brought forward to establish what his actual earning potential was?
He believed he was working to his actual earning potential in 2020. There was no testimony by him that he thought, yes, I could earn I should be able to earn $80,000. I believe that for child support purposes, he should just be, for worksheet purposes, it should be what his actual income is, because there was no, in this particular case, there was no vocational assessment of him or any other evidence other than his testimony as to what he earned. Now also...
So I want to make sure I understand. So are you saying that the history of what he has earned in the past, which there was a moment that was higher than his actual current, right? That gets trumped by the actual current, and the only thing that matters is the actual current.
Yes, Your Honor. What I'm saying is, yes, he did have some good years in the past. There's no question about better years. But he no longer had those jobs. He was let go of one or voluntary separation. That doesn't mean, although he was working a certain field back in 2016 through 2018, that doesn't mean he's going on a go-forward basis make that exact same money. He could make more. He certainly can make less.
I mean, what I find interesting is that your argument is premised that he cannot because he says that he cannot, but there's nothing in the record that's pointing to say, here's what's going on in the industry, or here how his skills are stale currently, or something to that effect. And so it always comes down to, like, who had the burden at that time?
Well, I believe in terms of determining potential income, the burden shifts in this particular case to the appellee to demonstrate what the potential income was. I believe the case law is quite clear on that. Howard testified as to what his actual income or what he expects to be for 2020. Potential income, the burden shifts, I believe.
Then it comes down to, was it reversible error that the trial court relied on the history of your client's earnings in order to make a determination on imputed income?
Yes, Your Honor.
Okay.
I agree. If I can address the issue of the extrapolation of child support, they're over $150,000 a year.
Just so you know, you're over time, but I'm going to give you a minute since
Okay,
you were
I'll
asked
be
a lot of
quick. Thank
questions.
you. They're over $150,000 combined incomes. I understand it's a case-by-case basis, but the court is required to consider the standard of living and the needs of the child and of the parents. There was zero evidence in this court as to what the needs of this child was. That was never addressed, and I believe it was inappropriate to extrapolate for those reasons. Thank you, Your Honor.
Thank you.
Good morning.
Good morning.
May it please the court, opposing counsel, I would like to start where Mr. Sapenzi had started, and that was with the child care expense issue. First of all, I want to point out that in this particular case, my client was the sole residential parent of this child. And in fact, Mr. Newstate had, once he left the relationship, he actually had no further contact with their child. So since basically June or July of 2016, she's had the sole responsibility for this child, financially and otherwise, because he has made the decision to not be a part of this child's life.
But it seems to me that father's main objection is that because of the household lifestyle that the child lives in and the income, that the child is nonetheless in a very robust environment, and that I think he felt that it was, I'm going to put words into it, fundamentally unfair for there to be imputed income under these circumstances. How would you address that?
As far as child care or imputed income?
I think the issue is that, well, the child care is part of the issue.
Okay.
That goes into, yeah.
All right, with respect to the child care in particular, my client is a pathologist. She has different hours, longer hours, where traditional child care just wasn't going to be able to meet the needs of the family, and she made that decision. But I also want to point out that the decision to hire this particular nanny was done by both of them jointly, and that is in the record. Where they interviewed this person, it was okayed by Mr. Newstate.
Was this before separation or
Yes,
after?
it was. He okayed the amount, which at the time was $13 an hour. It's now $16, but that was, again, in 2016. So he was aware of this person. He agreed with this person, including her rate, when they were together as a family. And then again, he chose to leave and then had no further involvement, and now wants to make an argument that this was inappropriate or unreasonable under the circumstances. But I also, besides the fact that my client is a sole residential parent, and as that parent gets to make these decisions, these parenting decisions.
Well, I think the argument isn't that it was unreasonable to have this nanny. It was unreasonable for him to have responsibility for this caliber of child care expense.
Well, I guess I disagree, because he made the decision not to help with this child financially at all. He could have certainly come in and established parenting rights and had some responsibility to provide care for this child. He made the decision not to. So this child was being cared for the best as possible by someone that had a very busy schedule, and a traditional child care facility was just not going to be appropriate under the circumstances. But not to...
Was there any evidence as to what a traditional child care facility would cost and the delta between that and the nanny?
There was not. I know that Mr. Sapensley talked about the cap that's been put in place in March of 2019. I would disagree as to the amount. It depends on the age of the child. It's certainly higher the younger the child is. But there was no actual testimony concerning what childcare would have been. But he wants to complain about this expense, yet he clearly testified, I'm spending $7,500 a month on paying my credit cards, which was more than the support order that he was ordered to pay for this child. He was flying all over the world to Chernobyl and getting married in Hawaii and buying his fiance a $14,000 ring, but he would balk at paying at most $1,500 a month for this child. And that was when he was earning about $123,000 a year. His support order now currently is $563. That's even less than half of a week child care expense for this child. So I think it's for him to say, well, I can't afford it. If you look at the totality of the circumstances, clearly he could afford his lifestyle, which he chose, instead of supporting his son. With respect to the underemployed imputation argument, first of all, as the court is aware, the standard in all of these arguments is whether the trial court abused its discretion. So certainly it's a very high burden that needs to be met by Mr. Newstate before the court should or would overturn this decision. But the court has to look at potential income. And as you pointed out, ma'am, that the factors the court is required to look at is not only what the person is making, but what potential income is. And there are factors in the statute in 311901C that states you can look at their educational background, their work experience, their life experience, the ability to earn income. And all these things, Mr. Sapensley said that Mr. Newstate couldn't maintain a job for more than a few months. That's not true. There's testimony that from at least 2014 to 2017, he was employed with Cedar Fair, which I believe is Kings Island, and he was making anywhere from $92,000 to $94,000 a year. He chose to leave that particular employment to go with a new company, Hullivis, to make $90,000 a year base, plus the potential for bonus income. So he could have earned over $100,000 a year with that company. And again, we're not sure, that I don't think the facts are really clear as to whether he was asked to leave, he had bad behavior and they wanted him to leave, but it was a mutual agreement to separate. But then he said, I've decided I'm going to start my own business. I am not going to search for employment that has W-2 income. And he made that decision. He stated that very clearly in the record. He made the choice not to find comparable employment, which makes him voluntarily underemployed. And that's when we look at the history and the fact he's got an MBA from Xavier.
Well, there's more to be considered involuntary whether someone's voluntary underemployed.
And that is true. And so part of it is, is there a reduction in income? But the other part of that, this court held in Sweeney, is you have to look at, was that reduction they have to look at it in terms of, are you servicing the needs of the child? Are you looking at what's in the best interest of the child and making this particular financial decision? And clearly it was not. It was his own self-interest that he
But
left his position.
what about opposing counsel's point that, this is an entrepreneurial risk? You're going out and maybe this turns out to be, a really great opportunity that could redound to the child's benefit. Doesn't look like that's happened yet. I don't know, but why can't that be considered?
It's not that it can't be considered, but if we look at the facts of this case, the first year he went into business, he earned with his contracts over $123,000. So he clearly, even being an entrepreneur, could have earned that type of money. And then when we're in litigation, now all of a sudden he can only make $20,000 a year or $40,000 a year. He voluntarily terminated those contracts that were earning him that money. So for that reason, I would disagree.
And is that in the record that he voluntarily terminated those contracts?
Yes.
And how is that in the record?
It is... the transcript pages 89, 92, 93, and exhibits 9, 10, and 12. He terminated his contract with VES, which is the one that he made over $77,000 with in one, and then I believe another $6,400. He was billing $200 an hour with that particular company, and then terminated that contract. And again, there was no testimony to say that he was unable to get new contracts, what efforts he made to get new contracts. Instead, he chose to live in an RV with his wife, with her business, helping her with her business, and earning less than $20,000 a year, allegedly, yet still living the type of lifestyle he was living when he was earning much more than that. So I think the court was certainly appropriate in imputing $80,000. I think it would have even been more appropriate to impute more than that under all the facts and circumstances of the case. The other issue is on the extrapolation issue. And in this case, this court has held that the trial court is free to use that extrapolation method. There's no requirement for any specific facts or findings. If the court chooses to do it, it's a discretionary issue, and it goes back to we believe that the court did not abuse its discretion in doing it under the circumstances of this case. And ultimately, what we're looking at now is where we are with the extrapolated worksheet. Mr. New states responsibility for this child is $563 a month. Considering all the expense this child has, that my client has full responsibility for this child, I think it was certainly appropriate under the circumstances. So if there's any other questions? Okay.
Thank you.
Thank you very much.
And you still have your 2 minutes. Yes.
Let me address the last point Ms. Dagnero raised. As I said earlier, on the extrapolation, the court is required to consider the standard of living and needs of the child and of the parents. This child needs are being met. There's a household income of $1.1 million.
That's counting her husband. And there's, as I understand it, there is a prenuptial agreement that says that he has absolutely no obligation to support this child in any way.
Correct. They're going halvesies on the child care, but yes, for the nanny on a go-forward basis. That's the only, as I recall, that's the only obligation on his part, correct?
So saying that the income is more than $1 million, I think is a little misleading because it's not her income, that counts his income as well.
Well, what I would say is that before, when the child was born, they were living down the street in a condominium that was just purchased for $340,000. They now live in an $850,000 home in Clifton. So by the advantage of being married, it raised all boats. There is significant, even without Dr. Calhoun's income, you're looking at a $400,000 wage earner. So this child's needs are being met.
Well, but it's a logical extension of your argument that your client should have no child support obligation?
Absolutely. No. I mean, one can make the argument, I am not. He has a child support obligation. It just needs to be a reasonable amount of child support.
Well, I mean, what's reasonable? Because, I mean, $500 a month doesn't seem extravagant to me.
If the court would then say $500 from 2016 forward, I would say, yes, Your Honor. That would be reasonable. But as you look at the child support worksheets, they bounce around all over. Maybe there's a high of around $1,600 to now the $500. But yes, if it was $500, I would say, yes, that's a reasonable amount. No question about it. Now, in reading the decision, I get the overall
So you have 30 seconds.
Okay, real quick. The first thing that Ms. Dagnero raised was that my client left the residence together. He was kicked out. He didn't get a choice of who the nanny was or who nanny would not be. He testified she would not accept no if I said, I don't want to have this nanny. My sense is it's correct. There's been no contact, which perhaps was a good thing, all circumstances considered, since he left, no contact with the child since he left. But in reading the decision, it almost feels that it was punitive, that somehow the trial court is speaking by way of support, saying, you left under the circumstance, you've had no contact, and I'm going to make the highest award of child support. And that would be an abuse of discretion. That would be punitive. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. Case number C210219 and 430, Charles A. Mainkaus versus Nicole F. Mainkaus.
Good morning again.
Good morning.
I would like to reserve 5 minutes in rebuttal, please.
Whenever you're ready.
Thank you. Your Honors, this is kind of a unique case for me, and I know that there was not a lot of case law from this court either on these particular issues. So the first issue or first assignment of error that I raised concerns the discovery in this particular case. So under Civil Rules 26, the discovery rules are pretty broad, that it allows a lot of leeway for attorneys to be able to be prepared for litigation in any case, so that there's no concern about somebody taking advantage, et cetera. And even if what is requested is not necessarily admissible, certainly if it has the ability to lead to admissible evidence, it should be discoverable. In this particular case, Judge Tolbert granted a motion for protective order so that Mr. Mainkaus did not have to answer the discovery that was propounded to him by my client. And her reasoning was that there was a prenuptial agreement and that information was not relevant. And I think that was the argument that was put forth by Mr. Mainkaus. The issue, though, and the concern is in this case, my client was hamstrung in being able to make the argument she did, and that was not to challenge the validity of the prenuptial agreement, but to challenge the portion as to whether a business was covered.
Well, but I guess my question about that isn't that just purely a contractual argument, saying like this business was not identified sufficiently in the prenuptial agreement and therefore it's not covered by it, which you really don't need discovery to make that argument.
To make that argument. But what we also have is that the business, we believe, because we don't have all the information, acquired 2 other business interests during the marriage. The question is, how were those business interests acquired? And I think that even Mr. Mainkaus would agree that depending on how it was acquired, it could arguably be marital. And because my client didn't have the ability to find that information or request that information, she wasn't able to expound on that at the trial.
So, go ahead.
It's my understanding that your client was provided with tax returns
That is
from her former
correct.
husband. What years was she provided with?
So she was provided with, I believe, corporate 2016 to 2019, and personal 2018, 2019, or it might be reversed. But the years were definitely between 2016 and 2019. So nothing from 2020, nothing prior to that.
So that would have included the time that they entered into the marriage, right?
No, they entered into the marriage, I believe, in 2012.
Okay.
So it would not have covered all of the years.
Okay.
And part of the argument, besides the business interest issue, is the unconscionability of spousal support, which part of my client's burden is to show that there has been a change in what the impact has been over the course of the marriage. So the information as to the time of marriage through the time of divorce is relevant. And that information, knowing what income is, what the assets were, these go into the global consideration as to what spousal support should be if it is awarded. And my client was not able to get that information based upon the trial court's order. And so for that...
I'm trying to understand what would, like, for example, what potentially would she have gotten that would have taken her out of the agreement from the prenup?
Well, whether it's unconscionable is whether there's such a significantly changed circumstances, whether changes in income, changes in financial picture.
But that's with regard to the spousal support.
Correct.
Right. I want to get back to your first argument.
Okay.
Okay? So with regard to these after-acquired businesses and this one business that the capital assets were disclosed in the prenup, and your argument is that, and your client's argument is that that particular business was not really addressed with regard to the prenup, and then that flows over into then the after-acquired, as to whether those should be also, equitably divided as opposed to adhered to through the prenup.
Correct.
So I'm trying to understand what would discovery have provided her?
With respect
Potentially, speculatively.
with respect to whether the business was a disclosed asset in the prenup, I don't know that there is much discovery to that. I think you're right, Judge Bergeron. It's a matter of contract interpretation. Or not even interpretation. The clear language of the contract did not have that business located in the prenuptial agreement itself. But with respect to the acquired businesses, you would need information as to were there contracts, were there any other agreements as far as purchasing, or documentation to show the purchase, where did the funds come from, bank account statements. These are all things.
Counsel, if the court were to determine that the business was disclosed on the prenuptial agreement, would it matter?
It would matter. As far as for this particular argument about discovery, where it would be important is those after acquired businesses for sure. Again, specifically regarding whether the business is in the prenuptial agreement, I would agree. I don't think you need discovery for that. The document is what the document is. But with respect to whether the other businesses were marital or fell within the prenuptial agreement, I do think you needed that additional information. You can't just say that the business was acquired. But even so, the terms of the prenuptial agreement.
I mean, the evidence in the record is the testimony of the husband, and he's saying, hey, this business that I had at the time that I entered the marriage has flourished so much that I was able to take the gains from that and then develop these new businesses.
Well, I have two arguments to that. One, testimony is not sufficient when we're talking about that. I mean, certainly that's one piece of the evidentiary puzzle. And what we're talking about with discovery, even if that information ultimately didn't come in, it's still discoverable. Just because it may not have been an admissible piece of evidence doesn't make it less discoverable. But putting that aside, I mean, we can feel free not to believe Mr. Mankhouse. He could be a completely incredible witness, and we need documentation to be able to support what he's saying. You have my client saying something completely different, and so how do we deal with that? We need documentation to support these arguments. So you can't just come in and say, well, I bought it with my business interest. But second of all, we're talking about—
Wouldn't that open the door for every prenuptial to be challenged by, well, let's just do a bunch of discovery and just see if we can challenge it, as opposed to a spouse saying, hey, I have a basis to challenge it?
I don't think so. I would probably say, doing this for 30 years, that most prenuptial agreements are not challenged because the parties enter into the agreement and they agree to abide by it. When there are issues with prenuptial agreements, they come to court. And when you come to court, you should have the rules that come with court to apply to the case. Ultimately, there could be a decision that the prenuptial agreement is upheld, and that's fantastic. But if it's not, the person trying to challenge it shouldn't be limited in how they present their case.
But my point is, shouldn't they have a basis to challenge it before they enter into challenging it, as opposed to use the lawsuit as creating a potential basis to challenge it?
I would agree, but then where do we draw the line? So are you saying that, me as an attorney, I think my client has a good argument. The other side is going to say, no, I don't think you do. I mean, that's part of this litigation process. That's every single case we're involved in. I believe something is a separate asset. The other side says it's not. So we present our argument.
But isn't that the beauty of the prenup in order to avoid that?
Yes, that's the hope. But when you have something that is maybe missing or not covered by a prenup, that is an issue.
Well, let's talk about that for a second. If the prenup had listed on the schedule this business, which is CME Services LLC, would you agree that that was excluded from the assets?
If the name was on the schedule, I would say no. And the reason it's already on there. But what I would say more importantly is in the prenuptial agreement itself, there is no reference to that business. It doesn't say business see attached schedule. It doesn't say business at all in the actual body of the prenuptial agreement. It doesn't say business bank accounts. It doesn't say even business assets. It just attaches this depreciation schedule from a tax return without
but I mean, I guess that's where I'm going is the depreciation schedule clearly identifies the business, it clearly identifies assets of the business, and there's somewhere else in here where it says, like, we're not going to be, bound to formalities here. We can give like rough justice on the asset identification. So my question is, like, what, if you get this depreciation worksheet, like, what is a reasonable person supposed to expect that this is?
I guess what I'm looking at is when we are trying to determine what exists at the time of marriage for, what is covered, what is separate property under the prenuptial agreement. There has to be a full disclosure, one, and you have to understand, the other person needs to understand the extent of that person's assets. What we don't have listed in that prenuptial agreement anywhere, what is the value of this business? Okay, so could potentially be an argument during the course of the case that any appreciation in value is marital. I'm not saying that it is, but it's an argument that could be made. If we don't have a value to start with, how do we know that information? We don't even have bank account information. We don't have any other assets. Were there accounts receivable? Was there goodwill? This company had been in business 13 years before they got married. But there's nothing to identify what the value of this business was, or to identify it as a business asset other than a few pieces of items which were not comprehensive. It was the only items that could be depreciated on a tax return. So it was not a full disclosure as that's required under the terms of this court's case law and the Supreme Court.
I'll give you a minute to address the spousal support argument.
Okay, with respect to that, again, it's an unconscionability aspect of it. We started off with the parties relatively on same footing with respect to what they're making income-wise over the course of the marriage. And my client's argument and what she presented as testimony and evidence is that with her input, the business went from earning maybe $200,000 a year to over $6.5 million a year. The company started with very few employees and Mr. Menkhaus and grew exponentially during the marriage. She testified that she was the one that started with the logo, the business email, the website. Although crude, she's the one that kind of got the ball rolling and laid that foundation for Mr. Menkhaus then to build on that and to grow his business. And her income still stayed relatively the same, but actually at the time of divorce, Mr. Menkhaus had fired her. She was working for the company as basically a contractor. He fired her, so she had no income at the time of the divorce, and she was able, 8 months later, to have some sort of income, but not comparable to what she was making. What it appeared to me is that the judge made the decision, well, Ms. Menkhaus has plenty of other assets. She has other income coming in. She doesn't need spousal support, so we're not going to find unconscionability, which is certainly not the standard. We're looking at a huge disparity in income from where things started at the time of the marriage to the time of the divorce that the court should have taken into consideration.
Thank you.
Is that okay?
Thank you.
Okay, thank you.
Good morning.
Please, the court, good morning. Ms. Dagnero. Ms. Dagnero is ignoring the most critical facts of this case. Number one, this was a prenup she wanted. She went to a lawyer. She had it prepared. She gave it to Mr. Menkhaus. He
Does it
signed
really
it with no
matter who
changes.
wanted it?
What?
Does it really matter who wanted the?
It does matter who wanted it, because this is not a situation where somebody got a prenup prepared, stuck it under the nose of somebody who didn't get a lawyer, who had no assets, and they signed it. Now they're coming to court to challenge it. So number one, she wanted it. She testified that she never asked for any further information. She didn't ask for any valuations. She didn't ask for any statements. This prenup was signed 2.5 months before the wedding. 2.5 months, which in the world of prenups is a very long time. She is also ignoring a couple things. Number one, there was never a challenge to the prenuptial agreement itself. There's nothing challenging it, which she acknowledges. She's not here challenging it. She was simply challenging whether Mr. Menkhaus's business was included as a separate property asset. She didn't want to set it aside because she wanted to keep her own assets, which had increased by, I think, $4 million during the marriage. She wanted to go after his business, although it's clearly identified. And if you look at the totality
what about her discovery point? Like, if I understand your argument, I understand the argument about the disclosure on the schedule, but if there are new entities that are created and she's not allowed discovery to ascertain who owns those entities, how they were created, what, just the basics of that, how is that not prejudicial to her?
Because under the express terms of the prenuptial agreement, which Judge Tolbert went on through in much detail, the only way to create marital property was for it to be titled jointly. That was the only way. The parties' incomes that they earned during the marriage were separate property. Any property they purchased during the marriage with their income or with their assets was separate property. And the only way it could become joint was to put it in their joint names. They didn't even have a joint checking account. So it doesn't matter what the source was of his purchase of businesses, whether he did it from his income or whether he did it from business profit. There's no way to get to it, because the only issue before the court was whether this business was properly identified and excluded as his separate property, which this court found that it was. So it doesn't matter. I don't even understand why this argument's being raised. The prenuptial agreement is valid. It's enforceable. She wasn't challenging it, and it says if it's not joint, it's separate. If it's not titled jointly, it's separate. To go down this side...
Ultimately, she's challenging just the enforceability with regard to the businesses.
She's just challenging whether it was properly identified. She was never challenging
and that gets me to, because this is what's interesting to me. When I look at the gross case and I look at the factors that are considered in the enforceability of a prenup, the factor that jumps out to me is that the agreement was entered into with full disclosure and full knowledge and understanding of the nature, value, and extent of the prospective spouse's property, okay? So when I look at that, and let's say that I apply that only to what is being complained of here, not to the entire agreement, all right? Is there ever an argument advanced that when the wife entered into the prenup that she did not have a full understanding?
It would be a rare occasion to see a prenuptial agreement, and I do a lot of prenuptial agreements, and I've been doing this for over 40 years, where everybody gets valuations done. They don't do it. What Judge Tolbert has repeatedly said was that if you want a discovery, the time to do it was then, not now. It was then. I asked her testimony there, did you ask for a valuation? Did you ask for any additional documents? No. She wanted the prenup to protect her assets, and she waived, as people do.
So that's what I was going to say. So in essence, what you're saying is she waived it at that time.
She waived it. They were living together. She knew he had a business, and she waived any further valuations. It was her choice. She had 2.5 months to do it, and her attorney drafted it.
Because it seems to me, I mean, and I want to be corrected if I'm looking at this the wrong way. That's why I started with the question of what are the tax returns that were provided.
They were provided.
That was the heart of my question there.
Okay.
Because it's whether the wife had an opportunity to fully understand the property as she was either entering or what was at play at the time that she was entering into the marriage.
Again,
into the prenup.
Well, there are waivers. She didn't ask for any additional documents, as people don't. People don't. They look at the schedules, they sign it, and if she wanted more, she would have asked for more. But she didn't. So now we have a depreciation schedule, and as Judge Tolbert pointed out in her decision, maybe that was all his business was worth at that time, was the equipment. We don't know. But at the end of the day, she signed an agreement saying,
we don't know, but we have testimony, right?
I'm sorry, about what?
But doesn't the husband testify with regard to what the income was being derived from the business at the time that the marriage?
I don't believe we got into that. We didn't get into it. It was simply
a
question as to whether this business was identified. And in reading all of the parts of the agreement, the court found that it was. And then we went to the issue of spousal support, which, as we know, she waived. In terms of the tax returns, by the time we did get to trial, because again, this is a non-issue, she had his 16, 17, 18, and 19 tax returns, including his business returns. We were there in January and February of 21. 20 hadn't been done yet. So she had the most current returns at that time because people don't have their tax returns generally done in February. So she had, if you look at the record, extensive cross-examination opportunities. It wasn't Ms. Dagnero, it was Mr. Kaufman. So he had extensive cross-examination of Mr. Mankhouse about his profits and losses, which Ms. Mankhouse wanted to turn that into his earning capacity. And what the judge found, first of all, if you read the judge's decision, and she, as the trier of fact, is the sole determiner of the credibility of the witnesses. And if you read her decision, she didn't believe her. She didn't believe that she had done all these things that she said she did, that she was the one who made the business successful as opposed to my client through his hard work over 20 years, which was supported by
Which goes to the
independent-
J factor, doesn't it? Whether she had contributed to the earning ability of the husband.
Well, earning ability and making a business grow, the value of profitability of a business and earning capacity aren't the same.
Okay.
If you look at the statute, earning capacity is contributing to somebody through education, helping them get a professional degree. Earning capacity isn't the same as having a successful business, and she's tried to equate them.
So what factor does that, if it were to equate into the factors of 3105.18, where would that go?
Well, the court evaluated every single statutory factor. That's overlaid by the standard of unconscionability. It's not a completely de novo determination. You have to determine whether her waiver, in light of her current circumstances, would be shocking to the conscience. That's the definition of unconscionability, to leave this woman without spouse support, who was worth, I think, $4.6 million plus.
Let me ask my questions then differently. If she had contributed to the profitability and growth of the company, where would that be considered in the determination of the unconscionability of the spousal support?
I'm not sure, because in this case, the judge made a finding that she didn't, that while she worked there, she was paid a salary, and it was twice as much as she'd earned at any other job, and that she was fully compensated for the services she provided, but she also found that the services she said she provided didn't increase his profitability. She made an express finding that her services, in fact,
I understand that.
did not.
That wasn't my question was if that were to be considered under what factor, not what the ultimate outcome was.
In terms of whether she had put him through school and he became a doctor and she supported him and had a job,
So
maybe.
you're saying that whether she had bolstered the business, increased its profitability, you're saying that that's a factor not to be considered?
No, I'm saying the court found that she didn't. The court made an express finding that she didn't.
I got that.
Okay, so maybe if there had been evidence that she had, maybe, but that's completely hypothetical and speculative because the court made a finding that she didn't. She found her to be non-credible. She found her to be non-credible. When you get to the issue of unconscionability of spouse support, there's 12 factors or however many there are. And if you look at the case law, the fact that a party has made more money is not a grounds for setting aside a waiver, absent other factors. She cannot cite to a single case. We have cited to many cases where the spousal support provision, the waivers have been upheld. And under facts very similar, short marriages, no children, party worked, had assets, and they weren't unconscionable. The Gross case, which of course is very old now, is a very unconscionable situation of a long marriage and a tiny spouse support award of like $200 a month. So that was not this case. Finally, I do want to address, so A, she wasn't hamstrung on her discovery, and I don't understand how she can say she was when at the end of the day she had the most current personal and business tax returns that existed right then. There's extensive cross-examination about it. The spousal support, again, is in the sound discretion of the court. The judge had the opportunity over several days to observe the demeanor of both of these parties and determine their credibility. She found that she was not credible, and that basically when she couldn't get his business, she decided to go after spouse support indirectly, and that his offer to employ her and pay her a lot of money that she demanded had now turned into her trying to basically take his business. when we got to the 23-23-51 award of attorney's fees, because of these things, the court found that she had no basis for her claims, that she knew that this business was included, that she just wanted to try to get at with no viable claim under the law, and that her claim for spouse support also had no viable claim, found her to be non-credible. And again, this is as Ms. Dagnero pointed out in her earlier argument, it's a high burden to overcome the abuse of discretion. The court is the only one who saw her and saw him. And she made a decision after days of testimony, hours of testimony over many days, that she was not believable. And she was solely there to maliciously harass and injure him. That's the finding she made with all the testimony, all the observations that she had the opportunity to make, all the facts, and all the exhibits. That was the determination she made.
So you're saying that it is absolutely clear that there's no reasonable lawyer who could make these arguments?
Well, I think that I think that she went under prong one. I think that prong one is that she did it intentionally and maliciously injure him.
Well, if there was a reasonable basis, then
She found there was no viable basis.
Let me continue.
Sorry.
So if there was any reasonable lawyer who could have made this argument, then I don't see how it could be simply to maliciously harm the other party.
She didn't find that there was any reasonable argument. After observing her and listening to her and looking at the
So you're saying
Dozens.
reasonableness and credibility are the same thing?
Are what?
So reasonableness of advancing an argument and the ultimate decision of credibility, you're equating that to be the same thing?
I think in this case, after hearing the arguments that were made and having the opportunity to observe the things that came out of her mouth, she found that they were so out of line, so not believable, that the only conclusion she could reach, having found no viable argument, was that she did it to maliciously injure and harass him. That was the finding that she made based on everything that she heard. So I think that her decision needs to stand. And I think that, again, we're not here on a standard. At one point, Ms. Dagnero argues that there's a manifest way to the evidence in property division. This isn't a property division case. This is a prenuptial agreement case. And we aren't coming to court in a divorce. Somebody's claiming they had a house, someone's disputing it. We're here with a prenuptial agreement that they acknowledge is valid, never challenged it, keeps everybody's property separate forever, unless they titled it jointly. These people lived separate lives. She charged him rent. He was a tenant in her house. He paid her $174,000 in rent over the course of this marriage, despite putting $188,000 of his own funds into renovating her house, because that's kind of the business he's in. She collected rent from him to the tune. She was a tenant. It was a business. They never titled anything jointly. They lived by this agreement, which was, if it's not joint, it's separate. So these new businesses, just those are side issues. Thank you.
Thank you. Attorney Stagnero, I wanted you to help me with regard to something.
Sure.
One of the arguments advanced and that was considered by the trial court in their determination of spousal support was whether the wife had bolstered the business and had increased the profitability of that business.
Correct.
Is that a factor to be considered under the statute, and if so, where?
It is. I would consider it part of earning ability. I know Ms. Boston argued otherwise, but I think that's an
Well, she kind of didn't answer my question.
Right. So overall earning ability would include, if your income is coming from a business that you run, of course, if that business becomes more profitable, that's increasing a person's earning ability.
Okay.
And I think that's under subsection J, but don't quote me on that.
Because what I find interesting is this, that's where the trial court considered it. It was under subsection J. Under the language of subsection J, it goes beyond training and so on, and it talks about earning abilities, right?
Correct.
And so in the determination of attorney's fees, and we're looking at subsection J, that hinges on credibility.
Partly.
Okay.
I mean, certainly credibility is a key in any type of testimony, any type of trial situation. But my client not only had her testimony, she also had documentation in the multiple exhibits that were introduced to support what she was saying. Again, it's not a matter of, when we present cases, we do the best we can, and, with the information that we have, that goes to the question is, was it reasonable? In awarding fees under that section on 2351, you have to show that no reasonable lawyer would have made those arguments, that there was no basis.
And that's
in
what
law.
I'm getting to. So when you're talking about something that hinges on credibility, how would that factor into whether a reasonable lawyer would advance that argument?
Well, I don't know that it's just credibility. I mean, I think when you're examining a case from a lawyer's perspective.
This is a softball, by the way.
Right, I appreciate that. You have to say, do I have some basis in law to make this argument? If there's no basis in law, then you shouldn't make the argument. Whether your client's believable or not, that really isn't part of that factor.
Right. So if Jay gives you a basis and it hinges on credibility, then I think it's very hard to say no reasonable attorney.
Absolutely, because really what this decision did, it's a chilling effect, and I can tell you it's being felt, that they're saying if you aren't going to win an argument, if you present something to the court and you're not going to win, you're going to get hit with a sanction of attorney's fees because it's quote-unquote frivolous. And that is not the standard. We should be able to present our arguments that are based in law and fact, and if the court doesn't side with us, okay, that's part of this litigation process. We're not going to win everything we present. But you can't penalize somebody from presenting a valid, reasonable argument if it's supported, and that's exactly what my client did. There's multiple cases that were cited during the trial phase and also in my appellate brief that support these arguments. Just because Judge Tolbert made the decision not to make that same, to go with her and instead side with Mr. Mankhouse doesn't make it any less reasonable. And this, to me, this attorney fee award is, to me, punishment because Judge Tolbert didn't like the fact my client was making these arguments when she had made this decision. I also want to point out that not once during this trial phase did Ms. Boston ask for attorney's fees. She didn't ask for it in her complaint. She didn't file a motion along the way. She didn't advance that argument at trial. She didn't submit fees at trial. This didn't happen until after Judge Tolbert made her final decision before the final merits hearing in the divorce. Then all of a sudden, it's frivolous, and the court awarded it. That is not the basis. The basis is, was there reasonable belief or reasonable cause to make these arguments, and there certainly was.
Thank you.
Thank you.
Okay, thank you both for your arguments this morning. We'll take the matter into submission with your timely decision. Have a wonderful afternoon. Case number C210477, B&T Business versus Kentucky Deal Holdings. Counsel, you can come on forward. Good morning.
Good morning, Your Honors, and may it please the Court, I'm Nick Zuccarelli of Cohen, Todd, Kite, and Stanford. I'm here representing a number of parties, B&T Business Ventures, Karma Express, Sat Farm, Daljit Singh, and Taminder Singh. Unlike the cases that we've heard about already this morning, there's really not a whole lot of factual determinations at issue here. This is strictly a matter of law.
And would you like to reserve time?
Oh, I'm sorry. Yes, 3 minutes, please.
Okay.
This is strictly a matter of law. The underlying facts of the case can be a little bit convoluted and a series of complicated business transactions. The distilled version of that is that my clients were leasing properties upon which they operated gas stations and convenience stores. There's a number of underlying disputes with regard to those transactions. But for purposes of this appeal, we don't really need to concern ourselves with the complicated underlying facts. The basis of this appeal is that my client's original trial attorney withdrew. During the time that they were without an attorney, a motion for summary judgment was filed. This happened about halfway through the discovery period. While they were without counsel, they didn't respond to that motion for summary judgment, and the court granted it, and in the entry made reference not to any of the facts or evidence of record, made reference only to the fact that a motion for summary judgment had been filed had not been timely opposed, and as a result, the court was granting the motion for summary judgment.
Well, the court also said that it duly considered the matter and found good cause to enter judgment in favor of DC Brothers. Is a trial court required to give all of their reasons for granting summary judgment?
Certainly not. And there was what I believe to be a bit of a straw man argument in the reply brief saying that I was making an argument that the court was required to make conclusions of fact and findings of law. That is not the argument. What I'm saying is that the court made reference only to one factor upon which it based its decision, and it was not the affidavit that was submitted with the motion or anything else in the record. It was only the fact that the motion hadn't been timely opposed.
Well, and we review this de novo. So even if the trial court had determined it on that issue, we look at it at fresh eyes. So why would it matter at this point?
It matters because the trial court is required to actually conduct that factual review. The appellate court cannot, for the first time, conduct the review of the evidence and determine whether or not summary judgment is appropriate.
But if the trial court says, I've considered the record and I'm granting summary judgment, how do we know that the court didn't do, as you're positing, didn't do the work?
It's an understandable question. I think that the entry didn't make it exceptionally clear that the court had conducted that review. Again, I point only to the fact that there is one paragraph addressing the basis upon which this motion was being granted, and it was the withdrawal of my client's original trial counsel and their failure to timely oppose the motion. Didn't make reference to the affidavit of Hassan Abdul Halal, which was submitted with the motion. Didn't make reference to the interrogatories answers of my clients, which were submitted with the motion, which in fact introduces evidence in opposition to the motion for summary judgment. It made reference only to, I won't quote the entry word for word, you have it before you, but it makes reference only to the fact that a motion was filed, it was not timely opposed, and it says, accordingly, DC Brothers moves for summary judgment, and then the very next sentence is duly considered and the motion will be granted. And there is voluminous Ohio law that's cited in the briefs that says we do not do motions, we do not grant summary judgment by default. There must be an evidentiary review. A de novo review is appropriate, especially, only in the event when the trial court has made that initial factual determination. What we have before us in this case is something else entirely. It is the trial court effectively granting a summary judgment by default. A little bit more to the standard of review, there was also some argument in the briefs, which was unexpected in my opinion, that this was to be reviewed on a plain error standard. I don't want to get ahead of myself and make counter arguments to arguments that haven't been proposed yet, but the Sanderford case was cited in the appellee's brief to support the notion that where a motion for summary judgment isn't opposed at the trial court level, the appellate court reviews it only for plain error. That's not what the Sanderford case holds. In Sanderford, we had a litigant who signed off on a scheduling order that afforded only 10 days to respond to a motion for summary judgment, was apparently dozing off at the wheel and didn't timely oppose within that 10-day period, and then on appeal said, court, please reverse because that 10-day period set forth in the scheduling order was unreasonable. And the court said, no, you had to object to that at the time the scheduling order was made. You can't proceed through the case and then later on say, I changed my mind, I'm no longer on board with the 10-day scheduling, 10-day opposition period. Cases,
So what would you say is the correct review when the summary judgment is unopposed?
It's de novo just as it would be if the summary judgment was opposed.
But if you make a bunch of arguments on appeal that weren't raised below, are we supposed to consider those because they weren't raised before?
No, certainly not. I think the only argument that needs to be considered right now is with regard to whether the trial court actually conducted a review of the evidence, the
So it's a procedural due process argument, essentially.
It is, I believe, yes. The trial court is the trier of fact on a motion for summary judgment. It's not the appellate court's responsibility to make that factual determination for the first time. And again, the language of the entry, in my reading of it, you stick to the four corners of that entry. It's pretty clear that the court is saying we're granting this because it's unopposed. And for that matter, the timing of the motion itself bolsters that theory as well.
Would you say that even when the summary judgment is unopposed, that the moving party still has to meet their initial burden?
Yes, exactly.
Okay.
That tripartite test of the Rule 56C still needs to be done. We have to find if there is. I could pull it. I'm sure you're as familiar as anybody with it. There's no genuine dispute as to any material fact, that the movement is entitled to judgment as a matter of law, that reasonable minds could make no conclusion except to grant the motion for summary judgment. All of that needs to be done, and going back to this entry.
So what would be your best argument that the moving party did not meet their burden and thus the summary judgment should not have been granted?
Well, because the evidence that was attached to the motion for summary judgment, if the appellate court was to go through the evidentiary review for the first time, which I don't mean to bore you and keep saying the same thing, wouldn't be appropriate to do that in the first place. But if you were to look at the evidence submitted with the motion for summary judgment, there is an affidavit that supports the movement's argument, the affidavit of Hassan Abdul Halal. And also attached to that motion for summary judgment are the interrogatories answers of my clients, which effectively say, oh yes, we had this oral agreement, here were the terms of the agreement, I was making payment in accordance with that agreement. We've got one bit of testimony in affidavit form that supports the movement's argument. We've got one bit of testimony in interrogatory answer form that supports my client's argument in opposition to it. On a motion for summary judgment, the trial court does not make a determination of credibility. So we've got one bit of testimony in support, one bit of testimony in opposition, and for that reason, that is a genuine dispute.
The facts are to be looked upon in a light most favorable to the non-moving party, right?
Exactly. So even in the event there were a question, you wanted to make a credibility determination, you would still have to side in favor of the non-movement. The courts are, they have a strong interest in hearing cases on the merits and having a trier of fact weigh in on all the genuine disputes that exist. And to dispose of a case entirely simply because one of the litigants' trial counsel withdrew and they didn't timely oppose a motion for summary judgment, it's not justice, and it's not the the purpose of the courts, really. And as I was going to jump into earlier, the timing of the motion presents a little bit of a question mark as well. This was a motion for summary judgment submitted about 3 weeks after my client's original trial counsel withdrew. It was halfway through the discovery period. The motion was granted very nearly after the expiration of the 28-day response period, at a time when my clients were still without counsel. So if this was a motion...
But, I hear you on that, but the scheduling entry says, dispositive motion shall be due by whatever date, no later than whatever date. So you can file it early if you want. And I can certainly sympathize with a client who has not been able to retain counsel because of whatever reason, but it seems like it's incumbent upon them to raise that issue and say, hey, we need more time, Judge. Here's my efforts. I'm trying to get counsel. I need a little bit more time. And then, you're not in this situation.
Yeah, it's understandable. I agree with you to some extent. And I'm certainly not making an argument that it was they were out of time or anything like that to file the motion for summary judgment. It's just that when you're halfway through a discovery period, 2.5 weeks after the opposing counsel just withdrew, and you decide now the time is right to file the motion for summary judgment, it raises some questions about why exactly was the time right then, and not 2 weeks prior when my clients had representation, and not 2 weeks later after they had gotten representation.
Does that matter?
It matters only to the extent that it tells to the timing of this motion was purposefully done to enact a summary judgment by default, which the court ultimately did issue, inappropriately so. If it were a motion for summary judgment as any other on the merits, why not wait until there's the end of the discovery period? Or why not wait until my clients have counsel to oppose the motion? This was specifically done in order to avoid all of that.
It's my understanding that the summary judgment was only the one party, the DC brothers, correct?
Yes, ma'am, yes.
And the claims against the other parties are continuing, correct?
Yes, ma'am.
Okay, so I'm having an issue trying to figure out how anything in those interrogatories suggested that DC Brothers was paid even a penny, or that any agreements were between your clients and DC Brothers.
Yeah, there's a question there's an agency question in this case as to whether Kentucky Deal Holdings was acting as an authorized agent of DC Brothers, who, it may be DC, I don't know if I'm saying it right. Whether they were acting as an agent of the property owner. Was
that argument made anywhere?
In the interrogatory's responses, it talks about an oral agreement made with Kentucky Deal Holdings acting, I believe it was acting on behalf of DC Brothers. If I'm mistaken about that, so be it. But that is the underlying premise, and it's an argument which my clients didn't have an opportunity to make because a motion for summary judgment was rendered at a time when they were unrepresented, and halfway through a discovery period. But yes, the underlying argument is that Kentucky Deal Holdings is a lessee of the property, but we're acting as an agent of the property owner in negotiating a sale of the property, as they did the first time. I understand the appellee's argument is going to be Kentucky Deal Holdings was not an authorized agent. Originally there was this written agreement that was, I believe it was titled as a lease-to-own agreement that was entered into between Kentucky Deal Holdings and my client. So certainly at that time, Kentucky Deal Holdings believed that they had a right to sell a property that they were leasing. My clients are saying, yes, in keeping with that, Kentucky Deal Holdings had represented to us the fact that they had the authority to sell this property that was, the titled owner being DC Brothers. But at the time we negotiated the lease, it was written in there that we had an option to purchase, and Kentucky Deal Holdings continued to make those representations.
Counsel, you have 30 seconds.
Thank you. I will just tie this up and say, we really don't need to concern ourselves with anything outside the four corners of the entry, which says summary judgment is rendered as a result of the lack of opposition to it, and including boilerplate language like duly considered and for good cause shown. It doesn't do much to help the dearth of information in the entry justifying summary judgment. Thank you.
Thank you. Good morning.
Good morning, Your Honors. Chris Jones for the appellee. Your Honors, this panel should affirm the trial court's granting of summary judgment to the appellee because under any review, it's clear that the court did not err at all, or at worst, any error was harmless because no genuine issue of material fact exists here for trial. Now, I do want to touch on a few critical undisputed facts. So the appellee is the owner of the property to issue. The appellee leased that property to Kentucky Deal Holdings. Kentucky Deal is a party to the trial court case, obviously not this appeal. Kentucky Deal entered into a separate written sublease of that property with the appellant B&T Ventures. Appellee was not a party to that sublease. That written sublease contained a purchase option, which the appellants have admitted in their brief they didn't exercise before it expired in March of 2019. Now, the appellant's complaint only makes claims and allegations with respect to that written sublease. The complaint makes no mention of this now purported oral contract. Indeed, for the first time, they identified a purported oral agreement with the parties under which they were to make monthly payments for 15 years, upon which time B&T would become the title owner of the property in their discovery responses. One other misstatement in the briefs that I do want to clarify.
Well, and you attach those discovery responses to your summary judgment motion, so construing it in a light most favorable to them, does that not create a dispute of fact?
It still doesn't, Your Honor. Those were attached to show the court, hey, first of all, this wasn't alleged in the complaint. They've now done a 180 and essentially contradicted the allegations that are in the complaint, which were based on this written sublease. Now they're saying, oh, well, all of our claims are based on this oral contract that wasn't alleged. So that was included to say, court, you shouldn't even consider this. And then to preempt the argument that even if you do, it's precluded by the statute of frauds anyway. And I'll get to that in a bit here, but that was the basis of including that in the...
Well, I understand what you're saying, but regardless, it was in front of the court, regardless of what the purpose was for it.
Correct. And I do want to make one other clarification, and the court may not find this credible, but those discovery responses were actually not verified. I just want to correct, in the briefings, in appellants' briefings, they said that that was sworn testimony. There was no verification included with those discovery responses, so they weren't verified. They weren't sworn testimony, and they wouldn't be competent summary judgment evidence to consider anyway. Your Honors, just moving on to the standard of review briefly, the court should review this under plain error. The appellant's interpretation of Sandifer really misunderstands the plain error doctrine. That doctrine stands for the proposition that if you don't raise or object to an issue at the trial court, then plain error review applies here. So here, the appellants didn't oppose the summary judgment.
So are you saying that not opposing the summary judgment is the same thing as not raising an issue or failing to object?
Correct, Your Honor. Yes.
Okay. Can you cite some case law or something, some authority that equates that?
Absolutely, Your Honor. Yes, in the Second District, USA Freight LLC versus CBS Outdoor Group, that's 2015 Ohio 1474, specifically in paragraph 22 of that decision, the Second District held that the plaintiffs in that case did not oppose summary judgment in the trial court, and so its review was confined to looking for plain error only. But here, Your Honors, even if the court conducts a de novo review as the appellant's request, the end result is the same because there is no error in the court's decision, again, or at worst, there is harmless error.
Well, so can you share your best argument as to why your client was entitled to judgment as a matter of law?
Absolutely, Your Honor. So first of all, with respect to the quiet title and declaratory judgment claims, again, the court really should not even consider this oral contract because it wasn't pled in their complaint. Even if it does get past that issue and considers the oral contract, then that was precluded as a matter of law by the statute of frauds. It falls squarely within the statute of frauds. It's an oral agreement, no signed agreement whatsoever, and the partial performance exception, as the appellants contest, does not apply. Specifically, that doesn't apply because this court has previously held that part performance requires an appellant to show that their acts were exclusively referable to the oral contract. Here in appellant's brief at page 3, they've actually expressly admitted that they made payments pursuant to both the written sublease and the oral land contract. So therefore, as a matter of law, those payments could not be exclusively referable to the oral land contract.
And you're referring to the brief before us?
Correct, Your Honor.
Okay, so
certainly there is no argumentation at trial court in this regard whatsoever. Correct. That's with respect
Isn't
to...
that what we should be looking at it in de novo, is what was before the court?
Correct. If the court adopts a de novo review, correct. And quite honestly, that's why the court shouldn't even look at the second, third, or fourth assignments of error, as Judge Bergeron had indicated earlier. Those weren't raised at the trial court, so this appellate court can't look at these new issues that were not raised previously. And Your Honor, getting to your point on the unjust enrichment claim and why we're entitled to that as a matter of law, that claim is precluded by the written sublease because that written sublease expressly covers the same subject matter as the unjust enrichment claim. In my brief on pages 17 to 18, I specifically identified the provisions that cover the same subject matter. I'll rest on that brief unless you'd like me to go through those in detail. But additionally, aside from that, there's no evidence here of any benefit whatsoever, as Judge Bach alluded to, being conferred on the appellee at all. There's no evidence of any payment whatsoever in the record being made by the appellants to the appellee. So there's simply no evidence of benefit for an unjust enrichment. For those reasons, we'd be entitled to summary judgment as a matter of law. Additionally, Your Honor, I do want to point out, I think in the briefs it was mentioned that the unjust enrichment claim is in the alternative, and they can assert that in the alternative. First of all, it's not in the alternative with respect to the appellees. A breach of contract claim was raised solely against Kentucky Deal Holdings at trial. And quite honestly, the fact that they didn't assert a breach of contract claim against the appellee at trial discredits this entire purported oral land contract now. Your Honors, I would also like to touch on, there was, in the reply brief, there is some citation by the appellants to the case of Murphy versus Reynoldsburg that I'd like to briefly address. First of all, that case is totally inapplicable here. That case involved a very narrow set of circumstances that are present. The trial judge in that case admitted essentially at the start of a motion for summary judgment hearing that it hadn't read any of the evidence. And I quote, the trial judge actually said, "Let me be upfront with all of you. I haven't read your motion. I haven't read your briefs, so educate me." And then that judge went on to rule solely on the basis of oral arguments. So it was clear from the record there that that trial court did not review the evidence, did not review the briefings. Those circumstances aren't present here at all. Not only is there certainly no affirmative evidence in the actual decision itself that the trial court didn't review the evidence, but essentially the appellants are asking the court to speculate based on some two sentences related to the motion being unopposed. That's not the standard. The court isn't, I believe it was, one of the judges alluded to the fact that the trial court's not required to explain its reason for granting summary judgment, and in fact, the appellant's counsel conceded that. That's absolutely correct. Indeed, I would point the court to Brittingham versus GMC in the 2nd District, where they held that reliance on this Murphy case was misplaced when there's nothing in the record to suggest that the trial court failed to consider summary judgment materials. That court also held that there's a presumption of regularity that applies in this context. Again, here, the presumption of regularity would apply, and there's no affirmative evidence in the trial court's record establishing that it granted summary judgment solely on the grounds that the motion was unopposed. There simply is nothing in the decision. There's nothing in the record in that regard. And I believe appellants essentially have conceded that. They're saying, well, the court should speculate and say, well, there's some language about an unopposed motion, but they don't specifically cite their, a detailed reason why summary judgment was granted. So then it was a default judgment based on that implication. That's not the standard, and that's not what this court should review. One last point, Your Honors, just with respect to, I don't think it was really discussed by the appellants, but with respect to the discovery issue, first of all, again, I mean, that issue wasn't raised at trial, so it shouldn't be addressed now. The mechanism to address that at trial is under Civil Rule 56F. The Supreme Court's plainly held that a party who fails to seek relief under Rule 56F doesn't preserve their right to challenge the adequacy of discovery on appeal. The appellants here clearly didn't do that. They've clearly waived their right to challenge that on appeal. But even disregarding that fact, in the record it shows the appellants from filing their complaint for 9 months until the summary judgment motion was granted did no discovery whatsoever. So they actually, it was actually their own inactions that led to the circumstances that they're now complaining of, and the court should not even entertain that whatsoever. Your Honors, unless there's any additional questions, I'll rest. Thank you.
I thank Mr. Jones for his arguments, and just want to address a few things. I think we've pretty well covered the issues at play here, but there was a number of references to harmless error, even if the court didn't conduct an evidentiary review, that this error would be harmless because, in Mr. Jones' opinion, the motion for summary judgment was meritorious to begin with, and there was. That's just not how, that's not the function of the appellate court. And we talked about Murphy versus Reynoldsburg. Let me read just a quick passage from it. The Court of Appeals concluded that its independent consideration of the record could in effect cure the trial court's failure to examine the evidence. We cannot accept that conclusion. That's as plain as it can be. The appellate court's function is not to act as the trier of fact and substitute in for a trial court who failed to consider the evidence of record. So the arguments as to the merits of the causes of action alleged in the complaint and whether or not the trial court's error was in fact harmless shouldn't be considered here. It should only be considered whether the trial court made that error to begin with. There was a more discussion of the interrogatories answers that were attached to the motion for summary judgment and why they were attached and for what purpose the movement did that. And Judge Bergeron, I appreciate your question or your point that it doesn't particularly matter why this was introduced into evidence. It was introduced into evidence, and it was attached to an affidavit.
But were the responses verified?
Yeah, that was actually new to me. I hadn't, because I wasn't the counsel at the time, I certainly would have counseled my clients to make a verified answer to these interrogatories. But one way or the other, they were verified when they were attached as an affidavit to the motion for summary judgment and saying, here were the answers of the non-moving party to our
well, that could be
request.
admissible as an admission by a party opponent, but as affirmative evidence, if it's not sworn, I don't think it's competent Rule 56 evidence.
It very well could be. You know, as mentioned, this was it wasn't in the brief. This wasn't discussed in the briefs, and so I candidly wasn't prepared to argue that point today.
So are you saying that opposing counsel has waived that argument?
I think that the arguments that are going to be advanced before this court need to be addressed in the briefs. Otherwise, I'm sure this wasn't intentional. I'm not imputing any ill will, but it's sort of a gotcha moment. I brought an argument before you that you weren't prepared for because I didn't bring it before the court either. That being said, even so, if we want to have that discussion of whether the interrogatory's answers as attached to the motion for summary judgment were sworn or admissible evidence in opposition to the motion, that's another determination for the trial court to make, which the trial court in this case did not make.
And counsel, you have 30 seconds.
Thank you. Well, I spent way more time on the first two parts of my rebuttal than I meant to. The standard of review we've talked about before. This is a de novo review. It's not a plain error. Here's one more passage I want to bring out. There is no default summary judgment in Ohio. An appellate court must proceed to analyze the merits of summary judgment de novo and examine all appropriate evidentiary materials filed by the parties, even when the motion is unchallenged. This is from Suriel versus Nationwide and a handful of other appellate court cases which cite Murphy versus Reynoldsburg in saying that in a situation where there's unopposed summary judgment, the standard of review is still de novo. We don't need to take it any further than that. So thank you very much.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. Have a great afternoon. Our last case C210363, State of Ohio versus Schilling. Good morning.
Good morning, Your Honor. Paul Crawshore for Michael Schilling. I would ask to reserve 5 minutes for rebuttal. This is an interesting case. It's very simple factually, but diving into the distinction between void and voidable.
Which changed recently,
I'm sorry?
Via Henderson changed.
Yes, ma'am.
As applied here.
Right. This is really purely an issue of law, and so I think it's a pure de novo review. In State versus Dye, this court held that, as sort of the flip side of this decision, that where Mr. Dye pled guilty to 3 F1 rapes and was misapplied the statute, and he should have been a sexual predator. This court said that decision was voidable and not void, because really the issue is how deeply are we going to get into void, and I think it's pretty simple. But I can't really distinguish the Lawson case from the Dye case. Lawson case, both of them cited by the prosecution, other than that the Lawson case was a per curiam made without full briefing because it was a pro se appellant, and is continually quoting void as putting void in quotes, and I think maybe the court was meaning that under those particular circumstances they were going to treat it as void instead of avoidable. But otherwise, I can't distinguish those two sets of facts. The issue is I think wrongly decided in Lawson.
And am I correct in interpreting your argument that what you're essentially saying is that he can only be subject to either the Adam Walsh Act or Megan's law, but not both simultaneously?
Yes, sir, because of the it wasn't a superseding law, but this legislature actually did away with Megan's law. So I don't think it even though it's a civil remedial, we've talked about the civil remedial nature of the classification system. Just the fact that the legislature specifically completely undid Megan's law, I think, means it's just not a superseding statute. I'm not a statutory scholar. I'm not a legislative scholar, so I can't provide much greater elucidation than that. It really is just a matter of a res judicata analysis. The question is what is the finality of judgments decades after they're made, or in this case, a decade after it's made? To what extent are we going to allow a judge in a motion to relieve a defendant of a registration requirement to go back and vacate as void the original trial judge's decision? I mean, this isn't a post-conviction. In the Lawson case, that was a post-conviction case that was brought back in front of that same judge, or at least the same court. Here we're looking at a special proceeding that was just specially brought. So we've got one judge vacating another judge's decision without declaring it void, and raising all this plethora of additional issues. I think Lawson was wrongly decided. I think the court's decision in Dye was correct. Here, Mr. Schilling was convicted in 2008 of taking a picture that invaded the privacy of a girl in 2007. Very different scenario from the 3 F1 rapes, for example, that we had in the Dye case. This should have been a fairly minor decision, and it should have gone final. And I think the court should allow it to lay to rest.
And what would be the net result of that?
The net result of that is that after
desire?
15 years, he would be eligible to terminate his registration without having to ask the trial court for permission, which is, in terms of his life, means he can get a job, which for the last 15 years has been effectively impossible, just because he's registered as a sex offender. And so on a practical matter, it creates a person who can support himself instead of living with his mother, and it recognizes the finality of a trial court decision.
And can you address the argument with regard to the tolling of the registration period due to his residence in the state of Kentucky?
Yes, ma'am. The record that the state provided shows that in 2008, Mr. Schilling did, in fact, report to the sheriff here I quoted that in my brief, and in fact, that comes from the state's evidence that they presented to the trial court. There's no elucidation as to what Mr. Schilling should have done that he didn't do. He went to the sheriff. The records of the sheriff show that in 2008, he was there. He told him he was going to be living in Kentucky. And for purposes of the Adam Walsh Tier 1, that qualifies as having met his requirement for being able at 10 years to ask for relief from his disability.
And how would you say that his registration in Kentucky with the sheriff in Kentucky meets the statutory language of the registration period of the requirements?
Well, Your Honor, as I read that statute, it's the period begins with that registration. I brought the statute, so let me pull it. 2950.15 C1 provides that an eligible offender who's classified as a Tier 1 sex offender is here, may make a motion under Division B of this section upon the expiration of 10 years after the eligible offender's duty to comply with, then that quotes the sections, begins in relation to the offense. So as I read the 2950.15 C1, it actually doesn't matter whether he, under the Adam Walsh Act, whether he was supervised by Ohio or Kentucky or even if, I think if he was in violation, the language of the statute would say that if they hadn't done anything about his violation, then he would still be eligible. Now, and that doesn't apply. He was very compliant. The materials provided by Mr. Bliley and Ms. Benzeca showed that he was generally a very law-abiding citizen of Kentucky. But there was no attempt to conceal. There was no running. There was no violations. They had some petty things that didn't relate to anything like this. I think traffic violations. But I think a big part of his problem was this being a pariah. I don't know how the society is ever going to overcome the fact that we've turned people who make mistakes and even if they're bad mistakes, become unemployable, who can't live anywhere, who can't do anything, who spend their lives in some sort of a subterranean world that we have forced them into. I think that's unfair. So if we have the
Counsel, you have a minute left.
Thank you.
No, you can continue. You have a minute
Okay.
left.
Just if we have the ability to turn them into productive citizens, I think we should take it as long as we're in compliance with what the legislature says. And in this case, I think the legislature said that Mr. Schilling should be eligible for relief from his Tier 1 requirements anytime after 10 years and, in fact, completely after the 15 years that he's about to complete. If there are no other questions,
Thank you.
I've made my points. Thank
All right.
you.
And you have your 5 minutes in rebuttal.
Thank you.
Judge Zayas, Judge Bergeron, it is very nice to see you all live and in person. Judge Bach, it's especially good to see you.
Thank you.
It really is. After 2021, it's really, really, really good to see you.
You're the special one this morning.
Yes, indeed. I apologize, Judge.
That's
I
okay.
didn't want to sing
That's
that one out
okay
here,
because I understand what you're saying. You know, unfortunately, she came on during the pandemic.
Yeah,
And so,
that's true.
yes.
So, I don't have a lot to say, but unfortunately, you all know me. I'll probably say it anyway.
So you're saying you want your 15 minutes?
Maybe.
I'll give them to you.
Maybe. With this, factually, the driving fact in this case is the offense date. This offense occurred in September of 2007. When you follow the line of cases that occurred in 2010 with Bodak, 2011 with Williams, and then 2012 in Ray Bruce S. and State v. Howard. It was abundantly clear that you cannot make Mr. Schilling a Tier 1 offender, as was the law in 2008.
Right, but I think that's what your brief doesn't really reconcile that point with Henderson and the New World Order that has emerged since then. And what I don't understand is you seem to be arguing that he's kind of subject to the Adam Walsh Act while simultaneously being subject to Megan's Law.
He's absolutely not subject to Adam Walsh at all under any circumstance.
But that's what he was sentenced pursuant to.
Well, that was only until 2010 when Bodak came out. When the Ohio Supreme Court said you cannot apply Adam Walsh to offenders whose offense occurred prior to January 1 of 2008.
But he was sentenced pursuant to that. He's registering in Kentucky pursuant to that.
No, he's registering in Kentucky pursuant to Kentucky law. He's not registering pursuant to Ohio law. He's registering in Kentucky.
Well, presumably Kentucky law says if you're subject to registration in
Correct,
a foreign
which
state.
all follows SORNA, which was adopted in July 2007
Right.
from the federal statute. Your
Right.
Honor. That applied to all the jurisdiction. If you're convicted of a sex offense in that jurisdiction, it follows that you register in the jurisdiction that you
Right.
move to. So, but ultimately this comes down to 2950-15 cannot apply to him because no portion of any of the Adam Walsh Act can apply to him. That's what this.
But I think this is where the Supreme Court essentially threw up its hands and said, like, our whole voidable void distinction has created an absolute mess. We can't continue going down this path. It is only void if there was no subject matter jurisdiction. The notion that you were sentenced under the wrong statute, like, that's gone. Like, we're not going to consider that anymore. You can challenge that on direct appeal, but we're not going to let you come back 10 years later or whatever and challenge it.
To follow that upends a whole line of cases, Your Honor, that the Supreme Court did not address with Henderson. They only looked at that component. They have not addressed this in any way, shape, or form. As to do so, you would be removing Bodak. You would be removing the holding of Williams. You would be overruling Bruce S. You would be overruling.
And while all of that is true, here we are with Henderson, and that's what's applying now,
Correct.
right?
Correct.
And so I don't know how we get away from the fact that he was sentenced under the Adam Walsh Act, that neither the state nor the defendant appealed on direct appeal.
Correct.
And that, the Supreme Court has basically created a situation of certainty regardless of error and regardless of whether that, the unconscionability of that error, the fairness of that error, the workability of that error, regardless of anything, sure, we're stuck with the sentence.
True, I would agree with that. That if Henderson truly applies here, and I don't believe at this point, and we would not concede that it does, in line with all of the other cases, because.
So you're saying that Henderson does not apply?
I do not believe Henderson applies in this circumstance, Your Honor, because when you apply the Megan's Law standard, his classification actually attached by operation of law in this circumstance. And that's what.
But I think the problem I'm having with that is the whole reason, as I understood Henderson, is to not go back and relitigate these things and is to appreciate the finality. And what you're saying is that, okay, he was sentenced under the wrong structure. Mm-hmm. That was wrong. We're basically going to pretend that he was subject to this other structure that he was not sentenced pursuant to. And that makes the trial court's order in 2008 completely fictitious from what it actually was.
Well, but I think that State v. Sullivan actually addressed that, Your Honor, because when they, to adopt the Henderson analysis, you are now voiding all of your Megan's Law classifications. So all of these folks that would have been reclassified after January 1 of 2008, all these people who were sexually oriented offenders that had been convicted of rape, that had their day in front of a judge, but to do so, you're wiping all of that out.
Well, it's not us, it's the Supreme Court.
I know, Judge. I mean,
But I think like it goes both ways. Like sometimes this benefits the defendant, sometimes this benefits the state. I mean, mistakes happen. And I think what the Supreme Court was saying as I read it was there's a paramount interest in finality. And even though mistakes happen, we're not going to like relitigate these cases in perpetuity.
Correct. So, again, I guess that's what you all have to weigh, and you have to decide, how does Henderson apply here? Because to do so...
But what is... sorry to keep interrupting
No.
you. But what,
I was actually looking forward to our conversation, Judge, I swear.
So where would we go to find a distinction post-Henderson along the lines of what you're articulating?
I don't think there is anything post-Henderson.
Okay.
I think that Judge Zayas highlighted this, that we're kind of in a brave new world that I don't know what it's going to do to us. I really don't. I don't know what it's going to do to finality. It's hypothetically speaking, recently had a case, and I'm not sure if it's come through here. I know that we did it about a year ago, where we had an offender that committed offenses post 1/1 of 08 and offenses that predated that. We had both a predator hearing and a Tier 3 classification hearing. What does that do to any of that? Does this completely nullify anything to do with Megan's Law? And the retroactivity that the Supreme Court said we couldn't apply to that? Does this make all classifications, past and present, punitive moving forward? I don't know.
You have me thinking of something I had not thought about before. So Megan's Law is really considered to be kind of, in a way, civil, right?
It is. Specifically, that's what the court...
So let me ask you this.
Yes, Your Honor.
If it was a civil case, no, we know this is a criminal case, right?
Yes.
If this is a civil case and there was an error in the judgment entry, what would be the remedies available to correct?
Judge Bergeron and I actually had this debate in Dye. In State v. Dye, that case, he was made a habitual offender based on two offenses that occurred in the same indictment. By statute, I think is Wilkerson, that's just from the first district, that specifically prohibited that. You cannot, to be a habitual offender, you've got to have a prior conviction and a new conviction, not simultaneous convictions, even though the offense dates are different. In Dye, we did not appeal that. He did not appeal that. He did challenge that later on a registration case, and we brought it back before the trial court, and the issue was void and voidable in that case as well. And that's what this court, I believe you authored a decision, Judge Bergeron. In fact,
They all run together.
they all do run together. I know. I'm still fact that, I'm hung up on that apparently love can't buy you money, or money can't buy you love after listening this morning while you have to swap gears on this stuff. But with that case, he was legally improperly classified. But because it was a voidable order that no one appealed, and we did not raise the 60B issue, it probably could have fallen under 60B, but we didn't raise that in the trial court. And so it wasn't right for consideration here. So you're correct. I mean, it is. I honestly.
But 60B would be the mechanism.
Correct.
And that's
you're absolutely correct.
Right. So, and that makes it really interesting because then,
correct.
In some ways, Henderson is giving less rights to a criminal defendant than a civil litigant.
Correct. Correct.
Yeah.
But other than a few variations between the statutes that that nudge it into punitive zone, you're looking at two classes of individuals, but it is a completely separate world that we're living in post Henderson, and I don't know honestly where it's going to go. I really do.
Mr. Lee, can you please address the argument about whether, when he registered in Kentucky, if
Correct.
that was counted as Ohio time?
2950-07E, both old law and new law, strictly exclude registration credit in another state. So you move from state to state. So you move to Ohio, and you've been convicted in Kentucky, You can bring forth credible proof, verifiable proof to the sheriff's department. Say you've been down there and you've been registered for 10 years in Kentucky. You can bring that forward to Ohio because the statute allows you to bring credit from another jurisdiction. If you've been convicted in Ohio and go to another state, it does not allow you to credit that out-of-state time against that to the sheriff's department.
Has there been any case law on this?
No, it's kind of an obscure point. I mean, it's clearly what the statute says. And I think
What's
that
the
it's
language in
really-
the statute that you're relying on?
I'm sorry?
What specific language in the statute are you relying on?
The specific reading of the statute, it's that it specifically excludes 2950-07E. It specifically excludes convictions for Ohio. It has federal, other jurisdictions, and tribal convictions, but specifically excludes Ohio. The question becomes if it's a 2950-15 issue, and which is sort of the elephant in the room that we're dealing with. Can you apply 2950-15 to offenders whose offenses occurred before 1108? It didn't exist under Megan's Law, so there was no mechanism to declassify after there. Well, there's no 15-year registration period to declassify after 10. In fact, all prevailing case law said if you're a Megan's Law offender, Section 1 offender, 10 years, you couldn't. There was no mechanism to declassify there anyway. But I don't know when you read the statute if it's merely the passage of time that allows you to file for 2915 or 2950-15 relief, or is it actual registered time? Because I know that if you're incarcerated under 2950-07D, it's told during periods of incarceration. Well, in a secure facility, you could actually be in a mental health hospital, and it's a secure facility. That's the same process there for actual tolling. So the statute's, again, sort of amorphous on that. It's not clear whether it's the passage of time or actually you have to be registered.
And just to make sure I understand the argument, so if you're subject to registration for 15 years in Ohio, mm-hmm. you move across the river to Kentucky, and for 15 years you duly register over there, then you're done. You're still living in Kentucky for 5 more years. And then after 20 years of living in Kentucky, you move back over here. At that point, you have to start registering for 15 more years?
Yes, because you can't claim credit for that time in Kentucky. Okay. And you're going to be subject to, and Kentucky now is 20 years or life. It depends on when and where your offense occurred. Like Mr. Schilling is considered.
So are you saying when the person moves to Kentucky, what is their registration requirement at that point?
So Mr. Schilling is a lifetime move-in offender in Kentucky because of the date of his offense. They have modified that to 20 years for some offenses, for Kentucky offenses, and lifetime for others. It just depends on the
Okay, so you're saying it's going to be governed by Kentucky law, but it tolls the registration period in Ohio?
Correct.
So it's not, it doesn't affect into a violation in Ohio?
Correct. Had he been convicted of a similar offense to this in Kentucky and moved here, he could ask for that credit to be credited to him towards a registration time here in Ohio. And again, it gets back to if he moves in, and in fact, Judge, this just occurred to me. So all of these people that have moved in.
So counsel, just to let you know, you have a minute.
Oh, sorry.
That's okay. Keep
I
going.
told you I'd be quick.
I told you I'd give you the 15 minutes.
I know. We have these out-of-state offenders who come in, and the sheriff's department has to determine, do we apply Adam Walsh Act? Do we apply Megan's Law? If they come in and they have the lifetime, the whole legal thing, you were there for it. Mm-hmm. And the application of that, we have, do we suddenly start treating them all as Adam Walsh offenders when they come in for their classification purpose? I think that we've got the unintended consequences of Henderson here that I don't know where it'll go or how it will affect anything. I honestly don't. I know that it is a much larger proposition than just saying simply, void and voidable, and we're stuck with the entry as it occurred. So, if y'all have anything else? I do appreciate it. I know that I was here 2 years ago, and we were one of the last ones before we wound down, and I was working diligently to avoid Zooming. We had this discussion the other day. I'm an anti-Zoomer. So with that, I'm glad we're back. So I
There you
appreciate it.
go. Yes.
Thank you.
Well, we all drank our coffee and we're ready for you this afternoon, this morning, so.
Thank you, Your Honors. Obviously, your relationship with Mr. Likos is much more extensive than your relationship with me. I'm not a.
But we like you the same.
I'm not a usual appearer on sex offense cases, but this section 295007E, the way I read this statute, it relates to people who are convicted in those other states. An offender who has been or is convicted, has pleaded guilty, or has been adjudicated a delinquent child in a court in another state has these connections. I don't see 295007E applying here at all. I think we're under 295015, and we're just talking about a person who has been subject to registration and not someone who has actually registered in any given place.
I mean, wouldn't there be some due process issues if someone offends in a state, is convicted in a state, and then goes to another state, and then that conviction has a different effect in that other state, even though that was not part of the sentence? Which is the argument that's being advanced by the state. That was a softball.
I don't know that there's a proper answer to that, Your Honor. I think that that it becomes much simpler if we apply Henderson to say.
Wouldn't there be some due process issues?
Absolutely.
And we're talking about people's liberty interests. I think that has some meaning here.
Right. I think there's a lot of due process issues. But if I'm, I've done some post-conviction, state and federal post-conviction, and I would say these same issues come up in Ohio cutting off post-conviction relief at a year after the transcripts are filed. And if you go across the border into Indiana, you have no deadline for filing a post-conviction on the same kinds of issues. The feds require full compliance with all of whatever the state requires, but so the same judge facing in a federal court who's considering an issue that comes out of, well, it'd be Fifth Circuit versus Sixth Circuit, but my point is you might have to apply that different state law to see whether you have exhausted all your remedies. That's as much a due process problem as here, because Ohio would cut that person off except for DNA or intervening Supreme Court decision.
I don't think that's analogous at all, because if you're under that circuit and that's what that circuit decided, and we have many instances in which the circuit courts have decided things differently, and that has not come to SCOTUS. Here we're talking about a conviction, a sentence in one jurisdiction, and then move to another jurisdiction, and now that sentence basically changes, because now just residence is the only thing that's changed. So
right. Yes, my analogy
it seems to me that your analogy is a little flawed, if you don't mind my saying.
It's not the best analogy, but it's the best I could come up with on this rhythm of. I think I'm a fan of simplicity. Applying Henderson by its own terms gives us a simple answer that gives us finality and certainty.
Right. Despite the unintended consequences.
Well, there's always these friction areas everywhere.
Including it's a little bit concerning that a party in a civil action would have more rights to remedy a judgment entry than a defendant in a criminal proceeding who has some pretty significant constitutional rights in being able to remedy that and only being bound to direct appeal.
Yes, ma'am. There is no doubt that in some ways the system is unfair. I can only say in the cases that I'm actually arguing before the court, the system, the unfairness goes to the heart of what we've done to people who make mistakes. I think that's as big an overriding unfairness issue of saying they have to go live under bridges somewhere because they can't live anywhere else, because we've so constrained the rules about where they're allowed to reside and what they're allowed to do, that...
Isn't that best heard on a constitutional challenge of the statute?
Absolutely. I'd love to have an opportunity to take that up. So far, none of
You've
my...
got to raise it in the trial court, and then maybe we can consider it.
Oh, yes, ma'am. I have a number of things that I've been working through the system for the past 30 years. But all of my attempts to get into... The only time I've been able to get to the Ohio Supreme Court, my Court of Appeals, which was, I think, the 4th District, took longer to rule than another case, and that case got to be first in the Ohio Supreme Court, and the U.S. Supreme Court has never given me the time of day. So I keep trying, and I will continue to try, and maybe I'll be able to make the point someday. But in the meantime, all I can do is advocate for the simpler the better and finality. I know that I may be in front of the court at some point arguing the exact opposite of what I'm saying, but my personal argument is finality is a good thing, even
I'll
where...
give you 30 seconds to wrap up.
Yes, ma'am. Even where you end up with a slightly weird outcome like here. That's got to be my position today.
Okay,
Thank
very
you,
good. Understood. Thank you both for your arguments and your time. We will take the matter under submission, issue a timely decision. Have a wonderful afternoon. Enjoy the weather. And that concludes our hearings for this morning.
The Court of Appeals, First Appellate District